Hey folks, welcome to Roll of Law. So Paizo has now released the final version of the ORC license. And if you're not familiar with this, this was brought about in the wake of the OGL debacle. And the OGL is a competing license, but they said, listen, we'll make a better license. This will be a better thing for the tabletop role-playing game community, and we'll share it with everyone, and hopefully this will take over. And a lot of people have had a lot of hope for this license. This license is a viral share-alike license, and we're going to talk about it. I previously did a video where I went through it sort of clause by clause, an in-depth analysis that might be a bit of boring lawyerese. This one is going to be a discussion of why I don't like the ORC and why I think it fails to achieve its fundamental objectives. So yeah, even if you are one of the people who really has big hope for the ORC, I hope you'll watch this video and just listen to what I have to say. You may not agree with my criticisms, but hopefully we can at least discuss them. I think there's room for more discussion on this. The ORC itself is final, but I'm going to be proposing an ELF license in a future video. So, all right, let's talk about the ORC, and we're going to start by looking at the ORC explanation document. They call it the ORC Acts, and it has a statement of purpose. So when we're judging this thing in terms of does it do what it's supposed to do, we're going to look at their reasons for it, because I might have different objectives than they do, and you might have different objectives. And if those objectives conflict, well, that's also a problem. So they say, why did you create the ORC? Role-playing games do an amazing job of infusing protectable creative descriptions with unprotectable game rules in a way that is challenging to separate under copyright law. I'd agree with that. This complexity has had a stifling effect on creativity in our industry. We created the ORC license to be a tool that gives you the right to use an ORC licenser's protectable game mechanics easily and confidently. So that's one of their objectives. It gives you the right to use an ORC licenser's protectable game mechanics easily and confidently. They also say the ORC license grants users a license to the copyright protection that exists in this complex form of intellectual property without publishers having to hire lawyers to separate that which is copyright protected from that which isn't. The whole point of the ORC is to give the gaming community comfort, confidence, and certainty. It gives our community a license that is not reliant on any one company. So there's a lot of goals here, but I'm really going to focus on the aspect of comfort, confidence, and certainty, and not needing to hire a lawyer. These are good goals, because if I am writing third-party homebrew for a game and I want to sell it, having to hire a lawyer is a big deal, especially if I'm doing it from my home office or, wherever. So this is it's a laudable goal, but I don't know that it really goes with some of their other goals. I think that, in fact, it's irreconcilable with some of their other goals. Let's keep going and talk about more of their goals here. So they say the ORC license substantially reduces the threat of litigation regarding these matters, which could easily bankrupt a small publisher who is in the right and operating in good faith. And that's true. If you end up getting sued by Hasbro, you are probably going out of business unless you have a lot of money to fund that. This is how we create what the open source community refers to as a virtuous cycle, evolving our games to be the best they can be. We're going to talk about that virtuous cycle or virtuous circle, because I don't know that it's all that virtuous here. All right, let's carry on here. I know that's a term of art, but still. There are some other provisions that they note, and we can infer a little bit about their goals from this. They say, why not Creative Commons? Because the Creative Commons already exists. It's available off the shelf. People have put a lot of work into it, so you could just use that, right? And they ran into two unresolvable problems, they say. The first is that Creative Commons just attribution share-alike, which they say is a share-alike license under which the initial licensor can limit their licensed materials to the creative expressions of game mechanics. Unfortunately, the share-alike provision requires the downstream community to share their entire work without the ability to designate any reserved material retained by the original publisher. Now, reserved material is things like characters, settings. If you think of Forgotten Realms, Elminster and Drizzt would both be reserved materials. So would the Forgotten Realms themselves, the whole sort of world there. Now, it's interesting that they're talking about how there's all of these benefits to this virtuous cycle and the virtuous circle, but they don't want that for this reserved material. They don't want you to be able to build off of their setting without their permission. Interesting. This only goes so far. It's virtuous circle for thee, but not so much for me. Especially considering that the first-party publishers, the people like Paizo or Wizards of the Coast, who are making the fundamental game, actually have a lot more ability to protect mechanics by separating them out and creating an SRD or designating that parts of a book are under ORC. Whereas if you are downstream licensing, you don't get that option to designate parts of a book under ORC and other parts not. The whole work has to be under ORC. So there's very different rules for Paizo, who's pushing this, than for you. Be aware of that. You don't play by the same rules here, and there is no way to fix that with this ORC license. They also note Wizards of the Coast released some of their content under CC BY 4, which is an attribution-only license. Attribution only means that the next person down the road has to credit you, but they don't have to share their material on. Any new additions, they can decide whether or not to provide to the community. So they say, which gives everyone the right to use the contents of the SRD Wizards of the Coast designated. This was a wonderful assurance for the gaming community that 5e could confidently be used forever. Unfortunately, if another publisher builds on that SRD, they are under no obligation to relicense their innovations to the community. This effectively kills the virtuous circle that open source communities are built on. But again, they don't want you doing virtuous circle things with their setting. It's very much a virtuous circle for some things, but not for others. So if you wanted, for instance, to build an adventure around one of their characters, you can't do that. All you can use is the mechanics that are there, and only those mechanics that they choose to ORC, because they can, as the first-party publisher, they can separate that out. Now, the ORC license, as I mentioned, is a viral and share-alike license. It requires that anything you do where you are relying on an ORC license, you also have to give away everything mechanical. And when I say everything, I mean like the entire spell description, the entire class description. If you use a single tiny piece of ORC material in a book that might be 1,000 pages of new spells, new monsters, new classes, the expectation is, and this is what the license tries to require, is that you have to give every single bit of that away to other people who might be able to copy it with attribution. They have to credit you, but they can sell it independently. So you might, for instance, be trying to sell a book of 50 new spells that you wrote, and somebody else compiles that into a book of 10,000 spells by taking bits from everyone else, and they sell it for the same price as your work. Their product is a better product. It's got, a lot more spells in it, and there is nothing you can do about it if it's under ORC. Nothing. You're just stuck. So you might not like that. And I'm going to point out that this is actually a very grabby license. And I'm going to use an example here. And the example is Kibbles Tasty. If you're not familiar with Kibbles Tasty, they do homebrew work, and a lot of their stuff is top-notch. In fact, I'd say pretty much all of their stuff is really high quality. I'll drop a link to Kibbles, but if you haven't checked out Kibbles Tasty's work for, D&D, you're really missing out, because a lot of their stuff is better balanced and better designed than Wizards of the Coast Zone stuff. It's just really good. And Kibbles Tasty is also really, really generous. And what I mean by really, really generous is that they have a permissions page on their site. And I'm just going to pull this up just so I can give you a little look. So what can I use Kibbles Tasty homebrew content for? And they say, I'm extremely permissive with what you can do with my content, which is accurate. I don't know that if permissive is the word. I would say generous. They're very generous to the community. In general, whatever you want to do is fine, with very few common sense exceptions. For more details, and they've got some stuff that's released under Creative Commons attribution only, and To the downstream, an attribution-only license is a lot more generous than a share-alike license, because a share-alike license is a gift with a cost, which is really a sale, right? You have to take on responsibilities, legal obligations in order to accept that. So the attribution has fewer of those and is therefore a more generous license. And they allow you to do all sorts of things, make copies, share it on a private Discord, share the free content on any platform, use it in live streams, videos, or podcasts, homebrew your own supplements, etc. that ties into the content. You can also do various things for pay. Share my paywalled content on public Discords within reason, so long as you're just doing it to play the game and you're not just lifting Kibbles' paid content in order to undercut Kibbles in the market. All of these things are allowed. And then there's what I'd rather you don't do, which is basically you don't have permission to do this. Repackage my content and present it as your own to sell on a storefront or similar. I wouldn't really think I need to elaborate on this, but it's been done multiple times. Kibbles Tasty is very generous with their content, and it's really good content, but the ORC would actually affect just about everything Kibbles does, because they do classes, subclasses, mechanical systems, that kind of thing. And so the very few limits that Kibbles Tasty sets on their work would be blown open by the ORC. In fact, the specific thing of, please don't lift my paid content and sell it on a storefront to get all the money. ORC says that that's okay. So we're talking about somebody who is very generous with the community, and does really excellent work. And they may not like the ORC. They may have very good reasons to avoid it, because the very few limits they put on that would be just gone. That, to me, is a problem, because I like Kibbles Tasty's work. I don't want to see somebody like that bullied out of the ecosystem here. In fact, I would like Kibbles Tasty's work even if they didn't have this big giant list of permissions. Because let's say I'm a third-party creator who wants to make things for Dungeons & Dragons. Well, if the game is better because Kibbles Tasty is selling work that gets more people interested and more people keen to play, if people look at Kibbles Tasty's Inventors class and say, wow, that is great, I want to get that on a table, and now I need an adventure. And hey, I might be selling the adventure. And so that actually benefits me. The community benefits by people like Kibbles Tasty existing. So there is a cost to the community of this sort of shared alike aspect. We may actually see people taken outside of their comfort zone and not willing to do it. I can tell you that there's a lot of people who are keen on the ORC license. A lot of people are very excited. And a lot of people are very excited partially because they're saying, screw Wizards of the Coast. And you know what? I'm on board with the screw Wizards of the Coast thing. You got me on that one. But I don't think the ORC license is a good license, and that's a problem. The OGL, lots of people originally thought that this would be a share-alike license, but it isn't. And that has actually been a benefit to the community, because it's made it possible for people to make this content and to make money doing it. A lot of people who are making this sort of good content are devoting a lot of time to it and have a financial incentive to do so. The other thing is that a lot of the best content has costs. If I was making a setting book, I might need to hire an artist to do maps, to do all sorts of things. And so I need to be able to fund that. Even just a book of new spells, people expect to see some artwork in there, and they really don't want to see Midjourney artwork. So I'm going to need to hire an artist. And I'm a lot more confident making that book and putting it out into the community if I know that I can charge for that, not get undercut by somebody who didn't hire an artist. All of these things, I want to at least recoup my costs. It'd be nice to make some beer money. It'd be great to get rich off it, but really it'd be nice to make beer money. And I am a lot less confident if I can do that if people can just poach my content wholesale. Now, that is sort of a problem with the whole idea of a share-alike viral license. And I've already noted that they want that standard for a lot of your works or Kibbles Tasty's works or that sort of thing, but they don't apply that to themselves, which we should kind of think, hey, is this really fair? And are these principles really great and noble principles if you're not applying them to everything, right? But we get into another problem, and that is this whole promise of you don't need a lawyer is I don't think it's a good promise. And this is fundamentally a problem of the ORC's plan, because the share-alike thing really is something where you want to compel people to do something. You want to impose a price, and in fact, a fairly heavy price, on using this content. And you might say, okay, well, sure, if you don't want to pay the price, you're not going to do it. The problem is that there's going to be lots of people who look at this and go, well, I'd like to pay the smallest price I can. In the same way that if you walk into a car dealership, you're probably not just saying, hey, I'm going to pay sticker. You're probably negotiating that car price down. At least I hope you are. If you're buying a house, there's probably some negotiations. They've got their asking price, and you're going to try to get it lower if you can. You may see people who want to use ORC content, but also want to give away as little as possible. That is where litigation lives. That's where you're going to get fights. And so anytime you want to make people give away things that they didn't want to give away, that is actually creating a ripe and fertile ground for litigation. This is where legal fights happen. The other problem is that there's a lot of people who are very keen on the ORC and don't understand the ORC and don't realize that. So what you're going to see is potentially some people who are ORC licensing their works and giving the full declaration, but they don't realize how much the ORC gives away. And when somebody else takes that material that they've given away, now they're looking for a fight. Now they're angry. There's going to be a lot of hurt feelings around this. This is a license that seems designed to create some hurt feelings and anger in the community, and I don't think that's a good thing. All right, let's get to some specific criticisms of where you could get this kind of litigation problem in the license, because there are some real possible places for that. So one of them is in the derivative works section. And so this is a way that you might see people who don't want to give away much content try to hedge content away. Now, I will note, I did point out to Paizo and Azora Law on their Discord, because one thing people said in my last video was, hey, why didn't you raise any of these criticisms? I did. And they patched some of the holes. And in the process, they made the ORC worse, in my opinion. But let nobody say I wasn't trying. But here, where there's this provision of multiple non-interoperable game systems, what that does is you have to give away your entire work if it's based on one system. But if you are using multiple non-interoperable game systems, then only the entire portion of the work related to or derived from the licensed material shall constitute the derivative work, which means you only have to give away the portion that is related to or derived from the licensed material. Now, what does that mean? Well, there's lots of different interpretations. Let's say I take a spell that somebody has put out under ORC, and I improve that spell, in my opinion, and put that out. But I also put it out in a work that contains multiple non-interoperable game systems. Let's say I throw in a chapter about how to play this particular dungeon under Fatal or something else. And don't play anything under Fatal. I'm just using it as a ridiculous example. But is it that spell that I've improved is almost certainly a related to or derived from the licensed material? However, let's say I add another 40 different spells. Are those related to or derived from the licensed material? Somebody downstream might certainly think so. They might think, hey, I'm allowed to use this. I might think not. And we may see lawsuits around that. So if you want to touch anything that involves multiple non-interoperable game systems, I would say you absolutely need a lawyer. And further, Azora notes as a general thing that this is a very difficult to read document. It's complicated. There's a lot of wrinkles to it. And they, quite fairly, they say, hey, we can't really solve that problem because we're trying to create a complicated system. But the notion that you don't need a lawyer to deal with a complicated legal document that is going to affect your legal rights is, in my view, irresponsible. Agreeing to a contract that you don't understand is always risky, especially if you're starting to talk about things that are close to your heart. If you've worked on a role-playing game system for 5 years and devoted, blood, sweat, and tears to this, you really don't want to screw around and potentially lose things that you weren't expecting. All right. So licensed material includes this phrase, and this phrase is going to be potentially a problem. Those expressions reasonably necessary to convey functional ideas and methods of operation of a game. What does it mean for an expression to be reasonably necessary? Well, Paizo and Azora law really intend for this to be broad in the sense of if I am using a spell, that the entire spell is probably shareable. But maybe, because what does it mean for something to be reasonably necessary? If I say that magic missile strikes inerringly at a target, is it reasonably necessary to say that it strikes inerringly? Is there another way to do it? Could you instead say that it always hits a target? That it impacts a target and cannot be dodged, evaded, avoided? There's dozens of ways to say it. I'm not going to try to think of them all as I do a video, but does that mean that it's reasonably necessary? Well, now you've just bought a lawyer a boat. If there gets to be disputes, and there might, because if I've just put out 50 new spells and I didn't realize that I was giving them away to the community, I might try to find a way to fight this. And if ultimately a court determines that reasonably necessary means you couldn't reword it, then the entire ORC license, the entire thing, basically goes into the trash. Whoops. And that happens because you force people to give away content they weren't expecting to. There are some other fun elements to it, and one of them is this bit, and I think this may trip people up. Reserved material notice. So the reserved material notice goes into your attributions, or your ORC notice. And it basically is intended to be something where you provide to the community just some hint as to what material they can't use. The problem is that the phrasing of reserved material actually specifies that nothing in that limits your rights or any downstream licensee's use of the adapted license material. And in the event of a conflict between your designation of reserved material and the definition of licensed material, the definition of licensed material shall control. Well, this is a problem because it means that essentially your reserved material notice is meaningless, legally speaking. If there is something that the reserved material notice says is open for use, like if I put reserved material notice, this work contains no reserved material. But I'm wrong about that, or I'm lying. And you want to use, a character, you want to use Drizzt or Elminster or whatever out of this material, then it's actually that legally I, as the downstream user relying on that notice, am in the wrong. That is also a potential place for some really fun chaos. There's also this, which might really trip people up, which is that you can expressly designate material that would otherwise be reserved material as part of ORC. Now, this is extremely risky. I am going to say that anyone who does this without talking to a lawyer is probably making a terrible mistake. And I probably will make an entire video on why you shouldn't give away a character in this way, like something like Drizzt or a setting element, the Forgotten Realms or any portion of it. If you had the rights to these things, you wouldn't want to give these away under the ORC license. There is real potential to get just absolutely screwed by that, because essentially the ORC license doesn't require the virtuous circle for any of those materials. So if you give away, you've invented a character, you've given away, Drizzt. Well, we're still using examples from Wizards of the Coast's protected, crown jewels of their IP, essentially. So you then, you've given that away. Well, somebody goes and builds on that character. The ORC license doesn't require them to give away any of those new elements back to you or anyone else. So they've now added things to your character that you can't use. This runs into some real problems. It's a real minefield. And so this notion that we're going to give this to the community and tell people that they don't need a lawyer to deal with a license that might in fact be highly contentious because you've got people being made to give away things they don't want to. Don't buy it. Do not buy it. Absolutely talk to a lawyer if you're looking at doing this stuff and you want to use this license. I don't think it's possible to achieve the goals of a minimal litigation risk document that makes people do things they don't want to do. Those are two completely incompatible things. If I have an easement on my neighbor's property that lets me cut through to get to the beach, say, and I'm in Alberta, there's no beaches, but it's an example. We're probably not going to get in litigation so long as my neighbor is cool with me walking down, that path. But if I get a new neighbor who's hostile, there's no amount of paperwork that you can write up that might not have you getting sued over them trying to close off that easement. Anytime you try to make people do things that they don't want to do, that's how lawsuits happen. Now, something else I want to comment on in the ORC is that the ORC is designed for one purpose, and that is tabletop role-playing games. And they say, they give some information in the acts that I 100% disagree with, and that is this. Can I use the ORC license for a board game? Yep, you can use it for any sort of game you can imagine. Well, you can. I mean, I'd agree in the technical sense of it is possible to use the ORC license for a board game. It is possible to use the ORC license for all sorts of things. Somebody on the Discord was talking about using the ORC license for comic books. I think that all of this is a really bad idea. The ORC was designed with tabletop role-playing games in mind, and the further away you get from that, the more it doesn't do what it's supposed to do. If you are going to make something like a board game, you should understand because a lot of a board game is not protectable at all, which is why there's a ton of different Monopoly alikes on the market. How do people protect their board game from being stolen? Well, if you don't understand that, if you don't have a good grasp of the various ways that you can protect a new board game, something that is special to you, that you've put a lot of work into. I mean, I've got a board game prototype right now, and I wouldn't want somebody else to just copy it wholesale once it's a finished product. If you don't understand that, do not touch the ORC for that purpose. I would say don't touch the ORC for even tabletop role-playing games unless you really understand it. And I feel like I do really understand how the ORC works, and I won't be touching it. I won't make anything under ORC because I think it's a bad license and I don't want to have any involvement in it. So this video is not here as legal advice. It's my opinions on a document. Don't take it as legal advice other than to the extent of talk to a lawyer if you're getting into this. But I am staying the heck away from this particular document. I think it is a really risky thing. Another thing I'm going to point out is that this whole virtuous cycle or virtuous circle, because they use both terms in the acts, hopefully they'll correct that. Pick one. Is potentially something that can be undermined by the share-alike provisions. And what I mean by that is that the ORC is a license that doesn't play well with other licenses. So one question that has been coming up a lot is, hey, if I want to make something that is an ORC, I need to use some ORC content because I'm making it, say, for Paizo's next game, because they're probably using ORC for that. But I also want to take some OGL released content and adapt it to the game. Well, you can't, because the OGL content requires you to have certain provisions in there, and these provisions conflict with the ORC. So what we can end up with is a whole series of these licenses that purport to make it easier for the community, but each of these licenses is incompatible with the others. And so you can end up in situations where there's things that you might want to do, but you can't, because these things just go together like, well, the examples I want to give, I think YouTube might be annoyed about because they're explosive, but, or dangerous. Think chemicals you can't mix in your toilet. Yeah, this to me is a real problem. And all of this, I mean, the one thing I really like about the ORC is that they've said that they're releasing the document itself, the ORC, as public domain. So you can actually build on the ORC license, which I'm doing. I'm working right now on the ELF license. And why is it called the ELF license? It's not an acronym. It's just orcs and elves are different fantasy creatures that, typically don't get along. So it's to rival the orc. And also, people say I look like an elf. So, the elf license. There we go. But the elf license is designed to really achieve the goals of not getting sued and being easier to use without necessarily needing, a huge legal team, without the share-alike provision, because that's where I think a lot of the getting sued lives. And there's a lot of things that are in the ORC that are worth taking and using. But the ELF license is going to be a license that doesn't ask much of the downstream users. It doesn't demand things in that way. And because of that, the ELF license is going to be a license that plays well with others. I'm actually planning to include specifically things that allow the ELF to be interoperable to the greatest extent that is available, such that something that is ORC content, you could add ELF content to. Unfortunately, then that ELF content is under ORC, which I don't like, but I thought about trying to make it so that you can't mix the two. And I thought, no, that's just me trying to be controlling for my own purposes. I don't want to do that. So really the goal of that, of the ELF license will be to make it as useful to downstream people as possible, but only giving away things that the upstream person chooses to give away. And because it's that choice to give things away, that is a real protection, because that if somebody says, I am giving away the following spells, in the same way Kibbles Tasty says, I am giving away, this book of spells. Literally, they've given away a whole bunch of spells to Creative Commons attribution. Then that that's something you can use, because they've chosen to give it away. They've chosen to allow you these rights, and therefore they're much less likely to sue you than if it happened by accident, or if it was something that was pushed upon them to use content they wanted to use, but they would really like to give you less than you might want to take. So those are kind of my thoughts. I don't think the ORC license is a good license to use. I won't be using it. I'm not going to tell you what to do and what not to do, but I really will encourage you to dig into the license and understand it very thoroughly before you touch it. Anything that has legal obligations and consequences has potential risk. And especially when you start messing around with copyright issues, because copyright has aspects of liquidated damages. It has aspects of statutory damages. It has aspects where you can end up owing a ton of money for what seems to be a fairly innocuous violation. It's a minefield. It's very much tread carefully land, and the suggestion that this document of contentious can be navigated without talking to a lawyer, I don't think so. I'm a lawyer, and I will tell you that as a lawyer, if I was looking to do a bunch of different things with the ORC, I would probably hire another lawyer to look over it, just to make sure. Anyway, those are my thoughts. Let me know your thoughts in the comments below. I know this one's a bit of a long one, but it's an important issue. And hopefully somebody looks at it and says, huh, I never thought of that. That's really the goal here. Anyway, thank you if you've watched this far. Thank you for watching. Like this video, share it with your friends, subscribe to see more content. My next video might be on the problem of ORC licensing out specific characters, but there's a bunch of other things I want to do, and I don't just want to talk about law geekery, because this is partially a channel to get away from the law aspects. Every time I think I'm out, they drag me back in. So, anyway, see you next time.